Many times each day, we hear stories like that of Maria Garcia Juarez as told by Michigan Public Radio. As she tries to adjust to a country she'd never known, Mexico, her American husband, Eric Orozco, remains in Detroit, suffering from leukemia and caring for their 2-year-old son, David. Juarez spent her entire life in the United States after her mother smuggled her across the border when she was 8 months old. Now 23, the former chiropractor's receptionist never became a citizen and was deported from Detroit in May of last year because she stole 2 cars when she was 17 years old. She never qualified for protection under the Deferred Action for Childhood Arrivals, or DACA program, because of the car thefts. Her family's story of separation, loss, fear, and estrangement is but one, we all know, amidst a humanitarian crisis for unauthorized Americans, a crisis that the U.S. Constitution's birthright citizenship provision, one that is held out as so exceptional in the world today and exceptionally robust, cannot reach or resolve. In the mid-19th century era of Reconstruction, there was a legal revolution that was unfinished at best. Ratification of the 13th, 14th, and 15th Amendments to the Constitution marked a sea change. Slavery was abolished. Equal protection to all citizens, regardless of race, color, or previous condition of servitude, was guaranteed. Voting became the subject of constitutional oversight. And these provisions marked an upending of the pre-war legal regime. Few would dispute that Reconstruction fundamentally reordered the nation's constitutional scheme by establishing new and far-reaching federal supremacy and laying the foundation for the culture of rights that was to follow. Since their ratification, the Reconstruction amendments have proven to be both highly durable and hotly contested. Birthright citizenship, my subject this afternoon, is among the most far-reaching and the most disputed of Reconstruction's legal legacy. The 14th Amendment broke a silence present in the Constitution of 1787 by providing, and I'll quote it only briefly, the first section, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. With this, birthright citizenship assumed a central role in arbitrating national belonging. Now, the principle of jus soli, or the right of the soil, had a long history in English common law. Still, it penetrated widespread consciousness in the United States only after its constitutionalization in 1868. Many 21st century Americans take for granted how birth quietly bestows upon them and their children citizenship, even as today much of the world limits the effects of jus soli principles. Still, birthright has always required careful interpretation and faced outright challenges. Recently, before the federal courts, was Tuawa versus the United States. Born in American Samoa, Lele Tuawa was challenged, he challenged his designation as a non-citizen national, arguing that he is a United States citizen by virtue of birthright. Historians of citizenship explain that despite their birth on United States soil, American Samoans have been denied the right to vote pursuant to racism rather than the Constitution. The Supreme Court has, at least thus far, let the second-class status of Samoan Americans stand. Other debates take up the status of the children born to unauthorized residents. Birth ties them to the United States. Still, some scholars of citizenship argue that such children may be deemed beyond the privileges of birthright. Legal historians have taken this debate from law reviews into the public sphere, and this view today is endorsed from the White House to the Twitterverse. Competing analyses turn on readings of the 14th Amendment, making the scope and the application of birthright citizenship a live question for us sitting here tonight. But it has been this way for nearly 200 years. Indeed, it's difficult to point to any moment during the past 2 centuries when citizenship was not the subject of debate. The Reconstruction era ratification of the 14th Amendment, in this sense, is best understood as an important but not definitive moment in the history of birthright. The import and the limits of events in 1867 and 1868, which I'll talk about some tonight, followed on the heels of a pre-Civil War debate over the status of free African Americans, former slaves. And they were followed by continued uncertainty about birthright when, at the century's close, questions plagued the children of Chinese immigrants whose parents were ineligible for naturalization. The 14th Amendment largely resolved the citizenship dilemma faced by former slaves. It did less well for the U.S.-born children of immigrants who, in the 1890s and today, face questions about where they are situated along the nation's borders of belonging. The earliest debates over birthright predate Reconstruction altogether. As early as the 1820s, lawmakers asked whether former slaves and their descendants were protected from arbitrary removal beyond the nation's geopolitical borders. And the answer turned on views about birthright citizenship. It was a constitutional puzzle generated, on the one hand, by colonization schemes that organized to entice, coerce, and otherwise remove former slaves from the United States, and on the other hand, by black laws that regulated the everyday lives of former slaves, how they lived, where they worked, how they traveled, how they made a living. All of these schemes conspired, if you will, to pressure former slaves to leave the country. The underlying premise in this period was that the U.S. could never be an interracial democracy. The question was only made more complex because close to the ground, federal officials conducted business in highly contradictory fashion. The post office, for example, barred black mail carriers at the start of the 19th century because they were not citizens, while customs officials issued to black sailors seamen's protection certificates that proved their citizenship, especially in foreign ports. Were they citizens by birthright, free people of color might enjoy the privileges and immunities guaranteed by Article 4, Section 2 of the Constitution. Black activists and their allies built a claim grounded in jus soli. Birthright citizenship, it was argued, bestowed a right to place, a right to remain within the nation's political and geographic boundaries unmolested. Congress took up twice the puzzle of black Americans and birthright in the 1820s, and on both occasions, I think it's fair to say, Congress fumbled. In 1821, a clause in the proposed Missouri state constitution mandated laws to prevent free Negroes and mulattoes from coming to and settling in the state under any pretext whatsoever. Congress asked, would a prohibition against the in-migration of free people of color violate the Constitution by drawing an impermissible distinction between citizens of different states? The resulting debate stretched over days and days with forceful advocates on both sides. Some said free black people were citizens. Quote, if a person was not a slave or a foreigner, but born in the U.S. and a free-going man into Missouri, he had the same rights as if born in Missouri. Others saw no conflict, the implication being that free black Americans were not constitutionally speaking citizens. In the end, Missouri was admitted, pursuant to a constitution that retained the troubling language. Still, Congress admonished the state. Never know quite what it means for Congress to admonish, right? Congress admonished the state not to enact any law that would further impair the rights of citizens from other states, including those of color. It's a fumble, right? 5 years later, in 1826, Congress returned to this question, reaching a similarly ambiguous resolution. A free black New Yorker, a man named Gilbert Horton, was detained in Washington, D.C. as a fugitive slave. Threatened with sale to cover his jail fees, Horton was freed with the help of Governor DeWitt Clinton, who demanded Horton's release. Horton was a citizen of Clinton's state, New York. New York Congressmember Aaron Ward placed Horton's circumstance before the House, asking the Committee on the District of Columbia to consider the repeal of any laws which authorize the imprisonment of any free man of color, being a citizen of any of the United States, and his sale as an unclaimed slave for jail fees and other charges. What erupted was what one commentator called a radical difference of opinion. Some lawmakers claimed as a matter of right that Black persons held to be citizens of the United States in the state of New York should enjoy in every other state the same privileges. Others maintained we have the right to exclude free people of color, to eject them, and to limit their privileges when we admit them to reside among us. The matter moved forward only by way of a murky compromise. Ward dropped his reference to free men of color as citizens, and with that, the committee proceeded with its inquiry. It was a fudge. Attorneys general also confronted these questions, and shades of Congress's indecision surfaced there too. In 1821, Attorney General William Wirt was asked if free Black men could command American merchant vessels when federal law barred non-citizens from commanding such ships. His answer was a qualified no. If free Black Virginians were not full citizens of their state, they could not be citizens of the United States. But Wirt's opinion left an opening. Were a Black person deemed a full citizen of his individual state, as was Gilbert Horton in New York, he might also be a citizen of the United States as well. 3 years later, in 1824, Wirt rendered an opinion on South Carolina's Negro Seamen's Acts, which provided that free Black mariners entering the state were to be detained while their ship was at anchor. He deemed the statute unconstitutional, holding that only Congress had the authority to regulate such commerce. It wasn't exactly an affirmation of free Black citizenship per se, but it put Wirt on the right side of the question. Wirt's successor was Roger Brooke Tawney, and Tawney revisited the question of Black ships captains as Attorney General of the United States in the 1830s. He was asked about the constitutionality of South Carolina's Negro Seamen's Act, and Tawney took a view directly opposite to that of Wirt, asserting that free African Americans, quote, were not looked upon as citizens by the contracting parties who formed the Constitution and have not been intended to be embraced in any of the provisions of that Constitution. He continued, that article of the Constitution which gives to citizens of each state the privileges and immunities of citizens was not intended to include the colored race. Tawney's prose countered Wirt's view while leaving unresolved, at least in his mind, whether Black Americans could be citizens of the individual states. The possibility that state and federal citizenship might not align or be otherwise linked was the same dilemma that Congress had sidestepped when it considered the Horton case in 1826. By the 1850s, courts were no less divided than had been Congress or the attorneys general. In the Dred Scott case, otherwise known as Scott versus Sanford, now Chief Justice Roger Tawney turned to free Black citizenship, concluding that the plaintiff, Dred Scott, and indeed no Black American, enslaved or free, could be a citizen of the United States in constitutional terms. Justices John McLean and Benjamin Curtis dissented. McLean's opinion recognized birthright citizenship, echoing the views expressed in Congress 30 years earlier. The first section of the second article of the Constitution uses the language, he wrote, a natural-born citizen, as in the president must be a natural-born citizen. It thus assumes that citizenship may be acquired by birth. Birth on the soil of a country both creates the duties and confers the rights of citizens. McLean went further and acted on his ideas. In July of 1857, just months after Dred Scott was decided, while sitting on the Federal Circuit Court for Illinois, he limited the application of Dred Scott in a case called Mitchell versus Lamar. Joseph Mitchell was a free African-American man living in Illinois, and he brought a suit against Charles Lamar of Wisconsin for damages in connection with an assault. It was a pretty ordinary case, except that the two were from separate states, different states, and the federal court might in fact have jurisdiction. McLean thought it did, And he reasoned that Mitchell, a free black man not descended from slaves, was a citizen. He wrote, "A free man who has a permanent domicile in a state, being subject to its laws and acquiring and holding property, in the payment of taxes and in the distribution of his estate among creditors or to his heirs or his deceased," McLean reasoned, "such a man is a citizen, so as enabled him to sue, I think, in the federal courts." It would be a mistake in light of McLean's decision and others like them to understand Dred Scott as somehow having settled the question of free black belonging in the United States. Justices sitting in lower federal courts would narrowly construe that notorious cases application. Lawmakers were driven by challenges presented by a visible and growing community of free African Americans, and they confronted questions about the nature of citizenship. They were not of one mind, as I hope I've illustrated, as the debate in Congress and differences between attorneys general and even Supreme Court justices evidence. What is clear, however, is that there was in the pre-Civil War legal culture a well thought out, a robust, and if muted, still a very present endorsement of birthright citizenship in the Constitution. But more familiar to us is the story of birthright citizenship thinking in the era of the Civil War and Reconstruction. Indeed, that period is often regarded as a starting place for our study of birthright. For us, with the pre-Civil War debates clearly in view, links to ideas that had their origins in the 1820s become apparent. What was new in the 1860s, however, was the potential for radical legal transformation that accompanied war and its aftermath. In 1862, Attorney General Edward Bates, following Wirt, following Tawney, had in mind these antebellum debates when he developed an opinion on free black citizenship. Bates was asked whether a black man might command an American vessel when federal law limited such duties to citizens of the United States. Now, I hope this question sounds just a little familiar because it's the one that both Wirt and Tawney had chewed on decades before. Bates reached, however, a different conclusion. He rejected the view that citizens might be recognized by the privileges they exercised, such as military service or holding office or voting. He acknowledged the Constitution's general silence, but viewed its recognition of natural-born citizens as significant, seeing no basis for an intermediate legal category between those of citizen and alien. The general rule, he explained, was that every person born in the country is, at the moment of birth, prima facie a citizen. Might race or color work to rebut the presumption of citizenship? No, Bates concluded after revisiting the reasoning of attorneys generals before him. The free man of color, he wrote, if born in the United States, is a citizen of the United States. And after careful study, Bates arrived at a view that was familiar to the era's students and scholars of citizenship. It was a view that was familiar to free black activists because the Attorney General echoed the arguments that had been made in Congress the generation before. Bates's opinion presaged new thinking in Congress about birthright. Between 1866 and 1868, through two quick, hard-won, and powerful agreements, Washington lawmakers took up the status of free black Americans with birthright as their centerpiece. They aimed at three barriers: the Dred Scott decision, the pre-Civil War black laws, now made into black codes, and the silence in the Constitution when it came to the rights that attended citizenship. The resulting Civil Rights Act of 1866 upset the pre-Civil War legal regime. Up front was birthright. All persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are hereby declared to be citizens of the United States. Swept away without comment was the long-standing threat of banishment or exile that black laws and colonization schemes had posed. In its place, or in their place, was an enumerated set of civil rights that gave citizenship new content, including the making and enforcement of contracts, the right to sue, be parties, give evidence, to inherit, purchase, lease, sell, hold, and convey real and personal property, and to full and equal benefit of all laws and proceedings for the security of person and property as is enjoyed by white citizens. With its ratification in 1868, the 14th Amendment became the touchstone for birthright citizenship, to which many of those aspiring to national belonging in the United States would turn. Still, the application of the amendment's birthright provision wasn't without controversy. Even the fine points of birthright were subject to dispute. As was apparent when the first black member of the U.S. Senate, Hiram Revels, arrived to take his seat in 1870. Revels had been a citizen for the Constitution's requisite 9 years, or had he? Perhaps not, some argued, if his birthright was set in place only with the 14th Amendment's ratification in 1868, 2 years earlier. Some objected, Revels was seated, but the debate over his eligibility signaled an important shift. None of his opponents doubted that Revels was a citizen, but at the same time, there was a question about whether the 14th Amendment functioned retroactively, such that he became a citizen on the date of his birth. And when he takes his seat, we assume, but only assume, that Congress concludes that he did. And so if the 14th Amendment works for men like Revels, it did not serve as an uncompromised weapon against racism inequality in the last decades of the 19th century. Forces lined up, including those consistent with white supremacy, to limit the amendment's meaning. And what Congress did next helps us see how the constitutionalization of birthright still left unresolved critical facets of national belonging, even for black men and women. A nagging vestige of the pre-Civil War legal regime remained. It was the Naturalization Act of 1790, still in effect after 1868, which limited eligibility for citizenship to free white persons. Black immigrants to the United States, those born outside of the United States, were not made citizens by the 14th Amendment's new birthright provision. Charles Sumner aimed to remedy this in the Senate and proposed striking the word white from the act. But this prospect met with opposition from those who feared that such a change would open the door to more than the naturalization of black immigrants. The striking of the word white might also make eligible for citizenship Chinese immigrants, some lawmakers warned. The revision's final language extended naturalization to, quote, aliens of African nativity and to persons of African descent, but no new provisions regarding Chinese immigrants were included. By 1882, the first of the Chinese Exclusion Acts closed this door tight, making explicit that Chinese immigrants would remain aliens. What of the U.S.-born children of Chinese immigrants, those natural-born descendants of permanent aliens? The 14th Amendment's birthright clause might appear to make it plain that they had a claim to birthright, but an interpretation emerged in the years after 1882, one that turned on the amendment's jus soli principle. It instead relied on this qualifying phrase, subject to the jurisdiction thereof. Those born in the United States were citizens except when they were exempted from domestic law and regulation, a provision that had initially in mind the children of foreign diplomats and children born to occupying armies. Anti-Chinese views led to a new interpretation. What was said to be an indelible foreignness, a loyalty to the Emperor of China held by such immigrants, was passed on to their children. The children of Chinese immigrants were said to be permanent aliens, like their parents, because their inherited fidelity to China rendered them incapable of submitting to the jurisdiction of the United States. When the case of United States versus Wong Kim Ark reached the Supreme Court at the end of the 1890s, it reflected the degree to which thinking about the 14th Amendment and birthright remained contested long after the end of Reconstruction. Not only were highly influential legal minds prepared to opine that children born on U.S. soil were not citizens by way of an inherited disability, Low-level administrators, including custom agents, held such views and were prepared to act upon them. Wong was a San Francisco native, and he had returned to the United States from China after a visit unmolested in 1890. But in 1895, he was detained upon arrival at the port of San Francisco. Custom collector John Wise and U.S. Attorney Henry Foote agreed that Wong should be rightly excluded as an alien. His birth on U.S. soil was overridden, in their view, by his indelible foreignness. Only rulings by the U.S. District Court and then the United States Supreme Court affirmed Wong's status as a birthright citizen. Was a child, the court asked, born in the United States of parents of Chinese descent who at the time of his birth were subjects of the Emperor of China, but have a permanent domicile and residence in the U.S., and are there carrying on business and are not employed in any diplomatic or official capacity under the Emperor of China, is their child a citizen of the United States? It was a lot of qualifiers, but the answer was yes. That those like Wong could not be excluded from the nation's boundaries resonates deeply with the claims set forth on behalf of free African Americans more than 8 decades earlier. Birthright citizenship was embodied in a claim to place, to remain, to come and to go, to return. Birthright has a history that extends across nearly the whole of the 19th century. It entered legal debates, as I've explained, during the antebellum era through a constitutional puzzle that was free African Americans. In the era of the Civil War and Reconstruction, birthright took on new significance as questions about the incorporation of former slaves into the nation led to the constitutionalization of the principle. Constitutional history gave it application, but it still was not a settled question. The children of Chinese immigrants confronted the denial of their birthright claims in customs houses and confrontations at the border that were settled only when the Supreme Court carefully examined the question for the first time. Defining who's a citizen is fundamental to a democracy. We might say that the contests over who is a citizen are also fundamental to a democracy. Our founding Constitution was silent on the subject in 1787, requiring the U.S. to only later settle on ideas about belonging. No 2 instances more so than those of 19th century former slaves and the 21st century's unauthorized immigrants have tested our laws and our beliefs. Former slaves and their descendants labored for generations in a legal limbo that birthright citizenship promised to resolve. In the decades before the Civil War, they numbered nearly 500,000 people, 1.6% of the nation's population. Most had lived in the U.S. for generations, building families, schools, and churches. Their labor was the engine of prosperity, be it on rural farms or urban cityscapes. Those same free African Americans lived under a constant pressure to leave the country. So-called black laws limited their travel, work, and public gatherings. Colonization societies organized to remove them to Africa, the Caribbean, or Canada. In 1857, the U.S. Supreme Court declared black people non-citizens of the United States, barring them from suing in federal courts. These forces aimed, indeed they conspired, to excise African Americans from the nation, whether by coercion or by force. A lack of citizenship defined this decades-long reign of terror, and it reached into the daily lives of Black Americans. If they were not citizens, could they own homes and businesses? Could they worship freely and govern their own churches? Could they control the custody and education of their children? Could they travel to visit family or secure jobs? Could they use the courts to protect their wages or their personal safety? No authority would say for certain where these non-citizens stood. The answers came by way of a revolution. 4 years of civil war and the near dissolution of the nation brought an end to slavery and the enactment of a new constitutional regime. The adoption of the 14th Amendment in 1868 guaranteed citizenship to those born in the U.S., including former slaves. Threats of removal were ended, even as questions about the full rights of Black citizens were yet to be answered. So there's much to admire in the work of Reconstruction-era lawmakers who took steps toward a more complete democracy. But today, their definition of what makes an American falls short of resolving our current citizenship crisis. Communities that include unauthorized immigrants find too little recourse in the birthright principle. Despite building families and institutions across generations, they are, not unlike former slaves, placed outside the nation's borders. The 14th Amendment provides them no relief. The once radical promise of birthright is beyond their reach. Their lives tell part of the story. The Pew Research Center estimates that in 2014, 11.1 million unauthorized immigrants, 3.5% of the overall population, reside in the United States. These men, women, children, these people have built families, homes, and businesses across generations. Their labors are an engine of prosperity. Integral to the country in which they led, today's immigrants nonetheless have no access to the rights of citizens. They have no unassailable claim to place. 2017 began with anti-immigrant threats of mass deportation. What followed has sometimes been more quotidian, but no less harrowing. ICE's workplace raids discourage even documented immigrants from their jobs. Public gatherings are canceled because community celebrations invite surveillance and apprehension. Parents and children are separated, some fear permanently, at our border. With no path to citizenship for unauthorized immigrants, the 14th Amendment's birthright provision operates as a generational scythe. Families of mixed status confront dislocation and separation as birthright slices through households, severing cross-generational ties. It is a haunted existence that produces lives subject to the arbitrary winds of politics and policy. A half-century ago, the 14th Amendment aimed to right a wrong. Its birthright provision recognized that thousands of men, women, and children faced the threat of removal because their legal status was not defined. Birthright was a remedy, a grand reform that acknowledged the lives and labors of communities of former slaves who had helped to build the nation. As non-citizens were transformed into citizens, generations of uncertainty and injustice were resolved. Black Americans would still face challenges, of course, to their political and civil rights in the years that followed, but the 14th Amendment ensured that they would never again face the threat of removal. Today, the nation faces a new challenge to our democratic ideals. How should we regard unauthorized immigrants? For these members of our community, for these Americans, the 14th Amendment does not promise inclusion. Instead, the shortcomings of our 19th century constitutional scheme are exposed as people said to be non-citizens face removal or, in 21st century terms, deportation. Without a remedy, we've begun to see friends, neighbors, coworkers, and even family members as outlaws. The 14th Amendment's ratification is rightly appreciated. This year, we marked its 150th anniversary. It's appreciated as an important step toward a more perfect union. Few doubt that Black Americans, indeed all Americans born in the U.S., are citizens. Still, the decades of insecurity endured by former slaves now echo through our own time, making sure and making plain how our nation tragically blundered and how it can yet again do the same. Thank you all very much.